Well, welcome everyone. Thanks for joining us here today. We had done this webinar a couple of weeks ago and got so much good feedback on it that we wanted to do it again. But we had some thoughts that we have people responding to us that they were having issues with the COVID-19 and, they'd maybe gotten their PPP money or maybe not. But the other thing was, we're moving into the recovery stage. And one of the things that we were talking about is, what are other things that you might be able to do? And one of them was that the feedback came back was, my lease is my next biggest expense. And so I have become good friends with the attorneys at Drew Eckel and Farnham, and I reached out to them and said, "Hey, is there anything that you could do to us and maybe help us put together some information about how business owners might be able to have conversations with their landlords about their lease?" And so I got introduced to David Rusnick, who is going to be speaking with us today. And we did put together a really good program, and we did it 3 weeks ago. And so I've asked David to do it again. And just to give you a background, David has been practicing law for couple, 3 decades from now. I think he told me that when he first started, he was actually working in real estate law during the savings and loan crisis in the mid '80s, and has spent most of his career working with commercial property owners, landlords, tenants, contractors, engineers, and financial institutions. He's licensed to work in Georgia and Texas, and as well as with the Supreme Court of the United States. And anyway, to say that he's been around and done this and seen most everything is an understatement. He has actually presented to the Georgia Institute of Continuing Legal Education, construction industries, and other education providers regarding liens, builders warranties, commercial issues, the whole gamut. So, David, I'm going to turn it over to you. Well, feel free through this, since there's only just a few of us that's actually in the program, feel free to turn your mic on if you have a question, turn your camera on. I see that Alan has got his camera on. And if you want to just ask a question, just like in a classroom, raise your hand. So David, thank you for joining us. The floor is yours.
Thank you very much, and I'm happy to be back. We did this a couple of weeks ago, and when we started off that program, one of the things that I said is that this was my third rodeo. I was a young associate back in Texas when the whole savings and loan industry decided to melt down. I was representing banks and other commercial entities at that time. And so I've seen this now. This is the third time. Everyone's been different. The savings and loan financial crisis was a function of bad lending practices. The financial meltdown of 8 years ago, was a securitized lending issue and how that impacted the industry. And now we have a very different cause for a meltdown. That is a global pandemic. But in the end, they're all the same when it comes down to the person who's actually trying to work through this, who's the tenant at a office or a warehouse or some sort of mixed industrial facility. It's all the same. You have to approach it with the idea of being proactive. What's different from what we did 3 weeks ago is now we have the Georgia governor, and I will avoid any political views, has opened up our businesses again, which means that some of the things that we were concerned about a month ago, about not actually being able to conduct business, not being able to have customers come into our stores. Well, that's now changed. Whether or not the customers are coming in or we're actually going back to our offices is another story. But we're in a slightly different landscape, and from that perspective, a number of our leases have force majeure and act of God clauses. And those things now are in a totally different place than they were 3 weeks ago. And I think we've also seen the beginning of a split between those people who are able to office remotely and their need for their offices and their leverage with their landlords or their landlords' leverage over them. And those of us who have storefronts or facilities that require us to be out in the public and providing services and need that space for either manufacturing or for staging our businesses that are public oriented. So we're starting to see a little bit of a difference there. But for the purposes of what I'm going to be speaking about today, I'm going to put those aside unless there's a specific question. And I'm going to try and talk to you about how to go to and deal with your landlord. Now, I represent landlords, everything from local shopping mall owners to folks out of Canada who do this, to folks out of New York who do this. And in the end, it's basically the same. If you're the tenant and you find yourself in distress because, well, you haven't had any customers or business for the last 60 or 90 days, what do you do? And so the question is, how do you do it and when do you do it? Let's take the when first. The when is now. Don't wait. Don't sit there and think maybe I can ride this out as my cash flow is being, rocked if I don't have customers coming in. Now's the time to approach your landlord if you think you are going to have distress. You want to be the first person in the door. You don't want to be the last person in the door, because by then, whatever flexibility the landlord really has, based on where their mortgage lender is, based on what their own concerns are, that flexibility may have narrowed and may have evaporated. So what do? Pick up the phone and call. You have a contact, you have a name, you might have a relationship. Certainly with the smaller landlords, that's going to be true. With the larger institutional landlords, it may be somewhat more difficult, and they may have somewhat less flexibility to deal with you or even to talk to you. But be the first person to pick up the phone. Be the person who says, look, this is my situation. This is what I'm worried about. This is what I'm going to be dealing with going forward. That I am or am not going to be a viable tenant. I am or I'm not going to be an ongoing business concern. So get that conversation started with the landlord now. Being proactive will save you from an angry landlord or a landlord who finds himself desperate with less flexibility. And I also think experience tells me that the people who are in first are going to get the better deals. And there are a certain number of deals that are to be made. Now, you may be dealing with a strip mall owner who is got a mortgage lender who is breathing down their neck. You may be dealing with a property owner who was intending to sell his property and is worried about their rent rolls or their cap rate or any of the other concerns that a commercial landlord or property owner would have. But if you're in first when they have flexibility, now you may have a better chance of making the kind of deal that you need to make. How do you do it? As I said, you need to pick up the phone and start the conversation on a personal level, but also as someone who does a lot of trial work, emails can be your friend or emails can be a real problem. People will write honestly in emails, but they won't say what they need to say well, or they'll say something in a way that can be misinterpreted. And that email is going to be read back to you someday if you're in trouble with a landlord in a courtroom or in a bankruptcy court or in a meeting. So my first thought is before you get down to writing things, talk. It's a lot easier to confirm something later than it is to have to argue whether or not what you said really meant what they are now thinking or saying you meant. So you've picked up the phone and you've called the landlord, you've called your tenant rep, you've called the landlord himself or herself. And now you want to say, what can you do for me? Or this is what I would like you to do for me. There are three basic ways to go about this. There is what's called a blend and extend, a forbearance agreement, or just an outright waiver of rent. A lot of landlords are going to be happy to hear blend and extend. And by that I mean is you restate your lease. Instead of it being a year, it's 2 years, or you extend the term of the lease. You maybe adjust the terms of the lease in terms of monthly payments or percentage rent payments or some other material factor that allows your business to go forward, but also gives the landlord assurance that 6 months from now, they still have a tenant. In a very rapidly changing lease market, the idea of having a secure tenant, someone who is going to be paying rent, as opposed to having to go out and hunt up a new tenant, well, that is going to be a very positive factor for you. Now, landlords are going to react differently to this. If they think your lease is undervalued, if you have an old lease and you want to blend and extend, you may anticipate they're going to ask for an increase in rent. Or if the landlord's feeling a little weak, you may find you'll be able to negotiate a lower ongoing rent going forward, or a different percentage rent, or some other material term of the lease that makes what you need to survive, to prosper, hopefully more than survive. Those are things you can address in a blend and extend scenario. Now, there's also what I said, or what I call the forbearance agreement. And that is an agreement where, yes, I won't pay rent for the next 3 months or month or however long, and the landlord will forbear or decline to take me down to the magistrate court and get me evicted. And they'll put that rent in sort of a box, if you will. And if I perform the remainder of the lease, the rent is waived. I don't have to pay it back. But if I fail to pay pursuant to the terms of the forbearance agreement, there will be a clawback or a snapback clause where that rent will come due again immediately. And if you are sued for rent in the magistrate court or in the state court or in a straight suit for rental, if not a dispossessory, then under those circumstances, you'll owe that rent. Which leads to the third form of thing you might ask for, and that's just an outright waiver of rent. You just go to the landlord and go, look, I haven't had any business for 60 days. I need 30 days off my rent, or I need you to waive 50% of my rent for the next 3 months until I get back on my feet. And the waiver of the rent is just a straight waiver. It doesn't come back. It doesn't snap back. You don't owe it at the end of the lease. You're not extending anything. You're simply asking the landlord for an accommodation. Now, some landlords are going to be very sticky about this. And I've seen a number of articles in various places in the country where at least the larger landlords with the larger tenants are being very slow to give any form of waiver. They are more inclined to a blend and extend or forbearance. But that's going to depend on the type of landlord that you have. And it's going to also depend to a great degree on your leverage. Now, whether you do a blend and extend, forbearance, or waiver may have to do with whether you're one very small tenant in a very large organization, or your landlord is a one-off shopping mall owner with 4 small boxes and 1 medium box, and they need your rent. They need you in there. They need you for the rent rolls. They need you for the cap rate if they're trying to sell. So it comes to, if you're going to negotiate, and I think I said this last time, one of the things you need to know is what other people are doing in the building or in the strip mall or in the complex, and what the landlord is doing with them. Because you don't want to be asking for something which is a complete outlier, and you certainly don't want to be asking for too little. So quietly, if you can, but find out what's going on around you. And not only just in your strip mall or in your building or in your warehouse, but what's going on around you in the community. Landlords may find themselves having to compete because if they don't want to do a deal with you, there may be a landlord just down the road who is willing to do a deal with you, who has the same or greater concerns, but has the capacity for flexibility. So in that sense, this is what you should be asking for. And the basis for what you should be asking is what's going on around you. Now, one of the things that you should be looking for, if you're looking for information, is what's going on with that landlord's lender. A lot of landlords do not own their property outright. most all have a lender, be it a community bank or a major national institution or even a hard money lender. There's going to be a lender out there. And what are these lenders thinking? Um, in terms of community banks and smaller banks, there could be a great deal of pressure here as bank examiners are looking at their portfolios and seeing that the landlords are not performing because they aren't obtaining rents. They're going to be looking at whether or not the bank examiners will be looking at what the banks need to be doing in terms of pressuring their clients, and those clients are your landlords. So be aware of that when you are negotiating with your landlord. What pressure are they under from their lenders? And what other pressures might they be under? If they are planning to sell this property or are thinking about refinancing this property, they need to be looking at their cap rates, their capital return rates. They need to be looking at their rent rolls, and rent rolls are a big factor. I think Alan, who's watching this, would agree that rent rolls are very important to getting refinancing. The third thing I think you need to be looking at in terms of what the lender might be thinking are really bankruptcy issues. Are the lenders worried that the landlord may actually have to seek relief in the bankruptcy court, be it a Chapter 11 or a Chapter 13, depending on the format of the lender? That's an issue for you as a tenant. If your landlord ends up in bankruptcy, you may find yourself having to deal not just with the landlord, who may not be the debtor in possession. You may find yourself dealing with a trustee or a committee as appointed by the bankruptcy court, and how they deal with you may be somewhat different when you're asking for some sort of consideration. Also, something else to consider and something to be looking at is a landlord subject to being foreclosed? Because you might find yourself being the tenant of a bank or of some other form of lender. Now you have a relationship with someone entirely different who has an entirely different set of priorities. If you find yourself the tenant of a lender who has now thrown you into a large REO portfolio, real estate owned by the lender, they may be looking at how they treat you very differently. They may want their rent rolls up, or they may not care, depending on the actual condition of the bank or the lender. And I guess another thing that I think we should talk about here is what you need to be thinking about if things aren't going really well. And you may need to think about some sort of a workout with your landlord, or you might need to be thinking about restructuring. Now, no one wants to think about this, but there are possibilities there, and there are things that you can do, and timing makes an enormous difference. Most of your leases will have an option in it for the landlord, and that is to terminate what's called possession or terminate the lease itself. A landlord can terminate the possession while the rent continues until such time as they find somebody new, and then mitigate what you owe. Or they can terminate the lease itself, at which point you not only lose possession through a dispossessor or eviction, but you lose, or the landlord then cuts off your obligation to pay any further rent. Now, these leases may have some sort of a rent acceleration clause in it, but that varies lease by lease. Your timing for seeking relief could be critical. If you are planning to stay in that place, stay in that space, and you want to be able to take your lease into the bankruptcy estate and then work your way out of bankruptcy with that lease, you need to get to the bankruptcy court before the landlord terminates the lease itself. The landlord only terminates possession, the lease still becomes part of the bankruptcy estate. If they terminate the lease properly as a contractual right, then there's nothing for the bankruptcy trustee to glom onto. And it's easier for the landlord to remove you from the property. The last thing I'd like you to all think about is, have you all business interruption insurance? Some of you do, some of you don't. Some of you have business interruption insurance that won't make a particularly large dent in any of this. Some might have good insurance. For all of you who are now currently back in business and are, because of our governor's order, but are still not really up to business yet, if you haven't already, if you have business interruption insurance, you should make your claim. I'm sure most of you have, but if you haven't, it is something to think about. We're in a position, I guess I've been going now about 20, 25 minutes, and I don't know that there are any questions at this point, but what I like to say before I at least wrap up, and if anyone does have any questions, I'm happy to take them. Be first, be early, be proactive, get on the phone, know what your landlord, know what their situation is if you can, know what the situation of similar tenants are in that property, in that area, and start looking at a good workout plan with your landlord if you're going to need one. The landlord's going to be under pressure. You're under pressure. Keep a cool head. Think about your business plan, and be sure you know what's in your lease. This is the one thing as a lawyer that I always run into is someone comes in and says, this is what I have. And then I read their lease, and it's not what they have. There's a lot of rumor. There's a lot of misinformation out there. One of the things I'm talking about in other webinars is what's called force majeure clauses, or the act of God clause. You have a lease that says that certain things will excuse you from being in default. Well, what specifically your lease says will depend in that particular clause as to whether or not it applies to your current circumstances. And I guess my parting comment is, don't depend on those without a close examination, and I would suggest you get your legal counsel involved. People are talking to me a lot about the act of God clause. Well, this pandemic is an act of God, therefore I'm excused. Well, not necessarily. Under Georgia law, an act of God is something that is beyond the involvement of man. Man can have had no involvement in it, and it can't be something that's foreseeable. Well, we've had in this country in the last century a pandemic that raged through the country, the Spanish flu back a century ago. We've had polio pandemics. We've had other flu pandemics. So the idea that a pandemic affecting business is something completely unusual and not anticipated or cannot be anticipated isn't necessarily going to be the case. Plus, if we're talking about an act of God and we're only talking about it in the context, or rather we're talking about it whether there's any human involvement, there has been a fair amount of discussion in the news late whether or not human involvement wasn't at risk or rather at fault in China, and whether the government of China could have prevented this, or whether the government of the United States could have done something to deal with this, or the government of the state of Georgia. So again, think very clearly about what's in your lease, read your lease, and if you need to, get some counsel. You may or may not have terms in your lease that help you, but just assuming you have something that helps, not the best plan, at least from the lawyer's perspective. Scott, I've been going now about 25 minutes. Do you have any questions, or Alan, or anyone else on the line?
I've got one, David. I would, and you've been very good about explaining it from the tenant side of things. And so a tenant has some space in a building that's owned by somebody else, whether it's a individual investor that has no debt on it, but there's not many properties out there that don't have some debt on it, or it's pledged for some additional debt, but there's an anticipation of cash flow that comes with that. And you know, from your banking experience and my banking experience, there's certain assumptions made of the cash flow that's going to support that loan. So if the lender, let's just say it's a bank, makes some modifications or accepts some modifications, do they have to actually modify the loan agreement? And do they have, if they have other investors, let's just say a REIT's involved, what's the notification chain to people that have skin in the game, and how many people have to say yes before an accommodation is made?
I'm going to do the lawyerly thing and say that depends on what's in the document.
Yeah.
Now, that actually brings up a very good point, Alan, because a lot of us who have leases have personal guarantees, and those personal guarantees may be worded as lease is or is not subject to notice and approval. Georgia law and law of other states on the right of a surety or a guarantor to be released if there's a major modification in the underlying obligations. It varies by the documents and it varies by the circumstance. But if you have a personal guarantee and your loan is being modified, they should be modifying your guarantee at the same time to show you have equal consideration, or there's consideration that's supporting the modification. I have been asked on occasion to help people get out of guarantees, and where the banks have been slow or unfortunately not particularly accurate in how they went about their business, they weren't paying attention, they've released guarantors under Uniform Commercial Code rules on workouts, on surety rules under the Civil Practice Act in Georgia, as well as under the Uniform Commercial Code, Article 2A. So everything needs to be in writing. And everything needs to be well documented, not just from the landlord side, but certainly from your side, because there are such things as mutual departures from documents, which will defeat very well-written non-waiver clauses. Your lease has a clause in it that says that no course of conduct or no failure to take an action will constitute a waiver, and the lease can only be modified in writing. Those are very nice, wonderful clauses, and conduct that's supported by consideration can waive those terms. You have to be careful about that from the tenant side, and the lenders have to be very careful, and the landlords have to be very careful about that from their side, because no matter how carefully written a lease or a guarantee is, if you are not abiding by the terms, or you're just trying to do business almost on the fly or on an emergency basis, and people go along with you or you go along with what other people are doing, you can end up modifying the relationship. Emails count, texts count as writing. What has to be written has to reflect what's actually going on. So in that sense, Alan, I hope I've answered your question, but it all has to be in writing, and everyone has to get notice who has a right within the document. If there are investors in a hard money situation, they may have veto powers depending on how it's structured. But everything has to be in writing, and everybody has to get notice. I guess
that's actually where I was driving at. Now that you've said it in a couple of different ways, but if there's a situation that's going to require some modification, the tenant needs to get the trusted advisors around the table, get the attorney, get the accountant, get the lender, and just say, here's the situation. Let's come up with a reasonable resolution, and let's paper it accordingly so that we don't have any unexpected triggers out there that causes somebody to stumble or get something other than what they were getting out of this renegotiation. So, good advice.
One of the things that came up in the last session, and I thought was very intriguing, it took a different spin on this than what we were actually looking at. But it may not be the tenant that goes bankrupt. It could be the landlord that goes bankrupt. And so whatever you deal with right now with your landlord, it needs to be documented with all parties involved, an amendment, because that document is the only relationship you have going forward with the new landlord.
Well, it gets actually worse than that. What if the bank goes under?
Oh, yeah.
And the bank now gets bought out, like so many did back in 2008 and during the savings and loan crisis back in the Southwest. The lender goes under, The lender is now flipped to a new entity. You've got some sort, or rather, the lender has some sort of a deal that's not particularly well documented. There's some allegations of misdeeds
Mhm.
between the lender and the landlord, and the landlord starts making claims that there was some other deal when the new entity takes over the bank. And therein, one of my favorite legal doctrines kicks in. It's called the Dench-Doom Doctrine. And it's a U.S. Supreme Court case from the 30s about fraud passing between entities which are taking over. When one bank fails, another bank takes it over. And it's codified in the United States Code, but it comes from a case called the Dench-Doom case, and it always sounded very ominous.
It
But
does.
what it is that it's a fraud doctrine that keeps a landlord from being able to claim that the lender committed fraud. Therefore, that is something that should relieve them of liability with the new owner of the bank after it has been passed through the RTC or the FDIC or whatever entity will be handling matters in the future. So the considerations go from tenant to landlord to lender to new lender, with the bankruptcy court being in between, and there being creditor committees and trustees. And it goes back to what Alan said, get everyone around the table. And it goes back to what I say, I think the very first thing I said, do it now. And by the way, call your accountant, because they have tax insights and they will be able to tell you about certain strategies that I, as a trial lawyer, am not either competent to talk about, or if I am competent, I won't talk about because I don't know enough about it. And I try not to get into areas that I really shouldn't be in.
Yeah. Fionlin, do you have a question that you might raise to David before we go? Let me see if I can turn her mic back on.
Do you want to talk? Hello?
Do you have a question?
No, we were just listening. We have a retail space, and we were just wanting to kind of hear what David had to say. It's kind of interesting because we're kind of dealing with this stuff right now.
Okay. Well, good.
I'm sure it's a little more interesting than you hoped.
No, it was good. Good information.
Glad to be of assistance to you, to Alan, to everybody who will be looking at this in the future. Again, speak early, know what you're going to have to say, know what you need to be thinking about in terms from the landlord's perspective. And, again, talk to people like Alan and your accountant, get your trusted advisors around the table, and then have an honest conversation. And good luck to everybody.
Well, thank you, David. I appreciate you giving us the time again. It's great information. We're going to, we've recorded this. We're going to post it up. And if anybody wants to forward any more questions, send them to me at the Chamber of Commerce, and I can get them to David.
Happy to answer any questions anybody has.
All right. Thank you.
And thank
Alan,
you for the job, David. Thank you.
Thanks everyone for joining us. Have a great weekend.
I know. Have a nice weekend.
Bye-bye.
Okay, bye.